Welcome everyone to Stanford University's annual Constitution Day Lecture. It's an important event for the university community, and it's wonderful to be able to hold it in person after being apart for so long. Constitution Day commemorates the signing of the U.S. Constitution on September 17, 1787. Federal law designates a Constitution and Citizenship Day and requires educational institutions receiving federal funding to hold an educational program on the U.S. Constitution on that day or a nearby weekday like today. Today, thank you to Judge Patrick Bumatay, who's here to give this evening's Constitution Day lecture on the subject of the value of dissent, an important constitutional value in which we express disagreements vigorously and constructively. This program is organized by the Stanford Center for Constitutional Law. Founded in 2006, the center focuses on the separation of scope of legislative, executive, and judicial powers, the structure of constitutional democracy, the freedoms of speech, press, and religion, and the right of privacy, including the privacy of personal data in a digital world. I will now introduce Professor Michael McConnell, who is the Richard and Frances Mallory Professor of Law and Director of the Constitutional Law Center. He's also a senior fellow at the Hoover Institution. From 2002 to 2009, he served as a circuit judge on the U.S. Court of Appeals for the 10th Circuit. Upon stepping down from the bench, he joined the faculty at the law school and took on the directorship of the center. Michael, I will now turn things over to you.
Thanks very much, Jenny. This is literally the first time I have spoken to a group of mostly students in a mask, so I hope you can hear what I'm saying. But I'm going to be brief, but I did want to extend a special welcome to the first-year students at the law school, whom I have not met, and Jenny has not met yet, but I see quite a few of you in the crowd, and welcome. Just one more comment on the occasion that brings us here, Constitution Day, that this has become, I think, maybe the signature event for a public lecture at the law school over the last several years. And we've made a real attempt to provide a diversity of perspective over the years. So you'll get to know our speaker for tonight. I'll introduce him in just a second. Last year, Margaret McCowan gave a lecture on the theme of the 19th Amendment. Dean Chemerinsky from the law school, which shall be unnamed across the bay, spoke the year before on free speech on campus. Justice Ruth Bader Ginsburg was our speaker a few years before that. We're very proud of the lineup, and I'm personally very happy and proud to be able to introduce one of the youngest federal appellate judges in the country, Judge Patrick Bumatay, to speak to us tonight. He's a number of firsts. He's the first Filipino-American to serve on a federal court of appeals. He's first openly LBGT judge on the 9th Circuit. And he's the first former law clerk, not of me, but of a colleague of mine, whom I've personally known to go on to the bench. He served for a number of years as a career prosecutor in San Diego, and also has been in white-collar defense work and in various positions of the Department of Justice. He attended the Yale College and Harvard Law School, but we'll forgive him for that and instead give him a warm welcome, Patrick Bumatay.
Thank you, Professor McConnell, for that kind introduction. As you mentioned, we first met in 2006 when I was clerking for Judge Timkovich on the 10th Circuit. I fondly recall spending time with you and your clerks in Salt Lake, although I do remember you took us on a hike and you vastly overestimated our abilities to hike, and that hike was really steep and really long, so we aptly called that trip the McConnell Death March. Happily, we survived, and we're here today. And it's really a great honor to be giving the Constitution Day speech. And first of all, it's a wonderful that we can meet here in person. And I see many of you students are taking my lecture topic to heart, and I think that's a good thing. Dissent is a good thing. Exercising dissent is a good thing. What's better, though, is dissent that leads to discussion. So I invite you all to come back and ask questions during the question period, or come meet me afterwards. But as I was saying, it's wonderful to be meeting here in person today after the last year and a half. I understand that many of the 1Ls are in their first weeks of class, and the 2Ls will begin their first in-person classes next week. So what better way to come together and inaugurate the reopening of the school than to celebrate the Constitution? I know this whole experience has affected everyone differently. But I imagine everyone has found a newfound appreciation for being around each other, for hearing people laugh when you tell a joke, and not having to unmute yourself when you want to speak up. So even though things are not completely back to normal, I'm really hoping you're all able to make the most of it, and I think this speech is a reflection of that. Before I start my formal remarks, I want to give a little background about myself. I'm a relatively new judge, and when I was in your shoes, I always thought it was fascinating to learn about judges' careers and backgrounds. First, let me tell you a little bit about my family's story. I think it's the quintessential American dream story. My grandfather came to the United States from the Philippines in the 1920s. He crossed the Pacific in a steamship with nothing more than a luggage in his hands. He landed in San Francisco and then earned a living picking fruits and vegetables through the farmlands of California. Through his hard work and resilience, he put himself through college and even earned himself a PhD. He then returned to the Philippines to start his family. My parents immigrated to the United States in the 1970s. They were lucky enough to have their medical education. But with not much more than that education, their hard work, family, and faith, they were able to build a beautiful life for my sister and me. And as for me, I've dedicated my career to public service. I spent the bulk of my professional life as a federal prosecutor in San Diego. I was a narcotics prosecutor targeting Mexican and South American cartels attempting to ship bulk quantities of drugs into the United States. But I also had amazing opportunities serving in Washington, D.C. at the Department of Justice. I spent time in all 3 leadership offices at the DOJ. First in the Associate Attorney General's, who's the number 3 at the office in the department, then the Deputy Attorney General, the number 2, and then the Attorney General, of course, who's the number 1 at the Department of Justice. For baseball fans, I like calling that hitting for the cycle at the Department of Justice. And now I serve as a judge on the Ninth Circuit. So as you can see, I think the American dream has struck my family at least 3 times. First with my grandfather, then with my parents, and now me. It is this background that inspires much of what I want to talk about today. As my family's experience shows, this country is truly the land of opportunity. We are an exceptional nation, and our legal institutions are surely part of that reason. So I start off with the premise that our Constitution is one of the greatest legal documents in the world, and our legal system is one of the best in the world. Building off that belief, the remarks I prepared for today have to do with the meaning and role of judicial dissents under our constitutional system. That is, the practice of authoring judicial dissents in appellate law, how it's developed since the founding, the various functions it serves, and what it reflects about our society. The origin of dissenting opinions is one of those areas of law we don't often learn about. You might think that legal opinions have always been structured the way they are today, but I think you'll find its history quite surprising. And it may be a strange topic for Constitution Day, because the Constitution says nothing about the structure of judicial opinions, writing concurrences, or dissents. But as a college student and as a law school student, I often found the most inspiration from beautifully written dissents about the meaning of the Constitution. Today, I find respectfully expressing my disagreements from my colleagues on the Ninth Circuit to be an important part of my job as a judge. So first, I'd like to briefly trace the history of dissents through our appellate history, starting with its roots in the English tradition. and highlight some of the most noteworthy court dissents. After marshaling through that history, I will discuss more pointedly the arguments for and against vigorous dissent. In the end, I think the history of dissent will show that they are critical to facilitating constitutional dialogue, not just within courts, but between the courts and other branches of government and the people. So where did the practice of dissent begin? An important precursor of our Supreme Court was the English court called the Courts of the King's Bench, a common law court dating back to the 12th century. The Court of King's Bench was always staffed with multiple judges, and they delivered their opinions orally and in seriatim, Latin for in series. In other words, each judge would take turns delivering their individual opinions orally in the same case. Seriatim opinions resulted in great complexity for the law, as you can imagine. It required accounting for and against for each position or argument of reasoning to determine what the precedent was. So therefore, you could see unanimity in judicial decisions wasn't a common goal in our early legal tradition. The English courts didn't publish official case reporters until the 17th century either. Before then, lawyers sought to memorize as much as possible from oral pronouncements. And then scribes tried to record as much as possible in writing. According to one source, the scribes were actually law school students, and their legal education consisted of recording seriatim opinions. So if you think Westall research is difficult today, just imagine having to research using students' handwritten notes. Still, the practice of delivering seriatim decisions proved remarkably robust through the centuries. Even after the appearance of official reporters, deciphering precedent remained an extremely arduous task. The result was a general lack of clarity in the law, as you could see some of the criticisms of the reporters that we've had through history. It wasn't until 1756, while many of our founding fathers were studying law, that the new Lord Chief Justice of the King's Court, Lord Mansfield, brought some order to the chaos. Lord Mansfield's goal was to create a more consistent and reliable body of merchant law for the growing commercial classes, which had amassed considerable wealth during the expansion of the British Empire. But the most important legal innovation provided by Lord Mansfield was the replacement of seriatim opinions with one unified opinion of the court. This reform allowed justices to deliberate privately and reach a consensus, both on the overall outcome of the case and the proper reasoning for that decision. The decision was then delivered as the unanimous and anonymous opinion of the court. The reform was profoundly successful, as many commercial plaintiffs would seek resolution in Mansfield's court, and it was emulated by various courts, including here across the pond in the United States. This is the world of law that our founding generation grew up in. Both seriatim decisions and unanimous opinions of the court found their supporters in early American society. When Congress established the federal judiciary in 1789, no provision was made as to whether these decisions were to be in seriatim or unanimous opinions of the court. A seemingly esoteric matter today, the debate between seriatim and unanimous opinions of the court would become a significant political issue in the first decades of the United States. This debate really reflected the divergent attitudes about the scope and power of the early federal government. On one side was Jefferson, who advocated for seriatim decisions because they increased transparency and accountability. They showed that each judge had considered and understood the arguments, and the vote count provided a weight for each precedent. So if it was 3-1 or 2-2, we would know which has more presidential value. According to Jefferson, each judge should, quote, throw himself in each case on God and his country, arguing that both will excuse him for error and value him for honesty. That said, as I said, the underlying motivation for Jefferson's preference for seriatim decisions was really a fear of a powerful judiciary, a federal judiciary. Jefferson viewed the courts as anti-democratic and recognized them as a threat to the decentralized, democratic republic. The confusing world of seriatim precedents and the lack of clarity that they result in helped restrain the aggrandizement of the federal courts during these early years. For the first years of the Supreme Court under Chief Justice John Jay, the general practice was to issue decisions seriatim and to announce a short summary of the issues agreed to by the justices. Under this regime, in general, dissents were not considered of minimal value, since the summaries focused on what the justices agreed upon rather than any disagreement. As envisioned by the Jeffersonians, this system of seriatim decisions weakened the early Supreme Court. For example, in one of the first important cases of the John Jay Court, Chisholm versus Georgia, the court held that a citizen could sue another state in federal court. It was a 4-1 seriatim decision with a lone dissent from Justice Iredell. Perhaps spurred by the lack of a unified voice on the court, Congress and the states immediately repudiated the decision and superseded it with the 11th Amendment. Today, Justice Iredell's dissent is considered closer to the state of the law than any of the opinions in the majority of Chisholm. So Chisholm might be one of the earliest American cases in which a dissent helped shape the future of the law. Things began to change with the appointment of Oliver Ellsworth as Chief Justice. Ellsworth was an advocate for a stronger centralized government and a more powerful federal judiciary. To augment power, Ellsworth favored the unanimous opinions of the court developed by Lord Mansfield. By issuing decisions for the court without dissent, now often called per curiam opinions, the power of the court and the national government would be increased. Per curiam orders made up at least 71% of the court's decisions under Chief Justice Ellsworth. But these per curiam orders often occurred in simpler cases, not involving issues of constitutional or statutory interpretation. Of the cases involving larger constitutional questions, you'll see half of them were delivered in seriatim and half of them were considered in per curiam. This takes us to the Marshall Court. John Marshall served as Chief Justice for 34 years, starting in 1801. Chief Justice Marshall was also a proponent of a strong federal government and a concomitant powerful federal judiciary. He, of course, favored a unified voice for the Supreme Court, which he believed would give it greater authority and legitimacy. Under this view, fractured decisions and dissents detracted from a concentrated federal government. And although Chief Justice Marshall, as a member of the waning Federalist Party, was politically outnumbered on the court, he proved effective at achieving his project of a stronger and unified Supreme Court. The Marshall Court would issue over 1,000 decisions over its 30 years, of which 93% were unanimous, a record unmanageable by today's standards. Under Marshall, most unanimous decisions were no longer delivered as anonymous per curiam opinions. Instead, they were signed and delivered by one justice, almost always Marshall himself, as the opinion of the court. It is said that Marshall managed to reach such frequent consensus through his personal charisma and sheer legal intellect. The legend goes that Marshall was so respected and esteemed by his colleagues that he even enlisted Justice Joseph Story, a renowned legal scholar himself, to do his blue booking. Marshall was once quoted as saying, "There, Story, that is the law of this case. Now go and find the authorities." I've done that with my clerks too. It is also worth noting that this was a different era. The Supreme Court justices all lived together in Washington, in a Washington boarding house for 2 months out of every year. They would eat, drink, and decide each case with very little outside contact. Perhaps the justices were willing to forego writing separately to preserve comedy on the court. Can you imagine what an amazing reality TV show it would be if Supreme Court justices lived together in one house and we filmed it? I would definitely watch it. Also, the type of cases decided by the Marshall Court was different than those decided today. The practice of granting petitions for certiorari didn't fully begin until 1925 when Congress enacted the Judge's Bill. So the earlier court had to deal with mandatory jurisdiction over several common law matters, such as property, family law, and contracts. Those cases were often unanimous, so it skews the percentage of dissents under that court. So the Marshall Court also saw the emergence and development of the third model of judicial writing, a hybrid style, with an authored majority opinion for the court, with other judges having the option of writing separately, either in concurrence or dissent. This is a model we frequently see today. This hybrid approach was something of a compromise between Chief Justice Marshall and Justice William Johnson, a friend and political ally of Jefferson. Johnson became the first frequent dissenter in American history, authoring about half of the dissents written by the Marshall Court, or about a third of his total writings. Justice Johnson was accustomed to delivering seriatim opinions from his time on South Carolina's highest court. In a private letter to Jefferson in 1822, Justice Johnson offered a different perspective on why Marshall found such success as a consensus builder. He called one of the justices incompetent. Another, he said, could not think or write. Still another was slow. And then he said two other justices were, quote, commonly estimated as one judge. I'm not sure what that means. But anyway, the point being, in Johnson's mind, the early unanimity of the court was as much a product of his colleagues' shortcomings as it was of Chief Justice Marshall's leadership. Despite these private sentiments, the tone of early dissenting opinions was quite respectful, almost forlorn. For instance, in 1805, Justice Bushrod Washington wrote the first dissent of the Marshall Court, explaining, in any instance where I am so unfortunate as to differ with this court, I owe it in some measure to myself and to those who may be injured by the expense and delay of dissenting, to show at least that the opinion was not hastily or inconsiderately given. Similarly, when Justice Johnson dissented in an 1807 case, he began by declaring, quote, I have the misfortune to dissent from the majority of my brethren. By 1827, even Justice Marshall could not resist writing separately. He dissented in part in Ogden versus Saunders. There, the Chief Justice used his rare dissent to articulate the principles of construction when interpreting the Constitution, a mode of interpretation that's still very much alive today. Namely, he said that the Constitution's words are to be understood in the sense in which they are generally used by those for whom the instrument was intended. By the time the Marshall Court was in its final days, there was obvious cracks in the idealized institution of a unanimous authoritative court that Marshall had built over 3 decades. The court was presiding over increasingly volatile and politicized controversies related to slavery. The rapid industrialization and expansion of the country also required the court, like most American institutions, to accommodate a more diverse set of views of the role of government, among other issues. On Marshall's retirement in 1835, Roger Brooke Taney took over as Chief Justice. Chief Justice Taney was different in many respects from his predecessors. For one, Taney did not try to preserve the unified voice that Marshall worked so hard to achieve. Fractured decisions would double to around 15% over the 3 decades of the Taney Court, unprecedented in American history at that point, but not unusual by today's standards. Justices increasingly prioritized their individual reputations over the unity of the court, at times dissenting without even explaining why they're dissenting. Indeed, the court was not immune to the increasing polarization of the country at the time. Compared to the apprehensive tone of the dissents we heard from the Marshall Court, sharper language in separate opinions became more common in the decades before the Civil War. For example, in one case, Justice Daniel wrote that he was dissenting chiefly to free himself from the trammels of an assent to the untenable and irrelevant positions of the majority opinion. It was in the context of this decline in civility and institutional cohesion, both on the Supreme Court and at the country at large, that the Taney Court would decide Dred Scott versus Sanford. Besides holding that the Missouri Compromise of 1820 was unconstitutional, Taney held that black Americans, even those who were born free, could never be citizens of the United States. I imagine most law school students still read a portion of Taney's indefensible opinion in Dred Scott. Doing so must be a jarring experience. If the unrestrained racism in Chief Justice Taney's language and reasoning wasn't bad enough, the decision is convoluted, it disregards precedent, and it oversteps the court's bounds. I think Dred Scott is rightfully viewed as a shameful mark on our country's highest court. But Dred Scott was also notable in terms of how it influenced the nation's constitutional dialogue and the use of judicial dissent. Many people mistakenly believe that Dred Scott was a unanimous decision, as they've only read Taney's majority opinion. But in fact, it was contentious within the court, and inadvertently resurrected seriatim opinions. On top of Taney's opinion, the court produced 6 concurrences and 2 dissents. The most powerful and famous of the dissents was Justice Curtis's. Justice Curtis had never been an anti-slavery advocate or abolitionist. In fact, the Harvard Law grad had supported the fugitive slave law in 1850. Still, to his credit, Justice Curtis carefully rebutted the majority's arguments, drawing upon historical, constitutional, and legal arguments. Curtis's powerful dissent is considered to have set a new standard for constitutional opinion writing. Notably, Curtis made the unprecedented decision to send copies of his dissent to the Boston Press to be published on the same day that the decision was to be delivered. Justice Curtis's dissent then was perhaps the first instance of a judicial dissent being used as a vehicle to foster constitutional dialogue with the public. Abraham Lincoln was said to have read it and been inspired by Curtis's dissent, and he spoke about it in his speech. Chief Justice Taney would never forgive Curtis for the Dred Scott dissent. And with hostility within the court would compel Justice Curtis to resign and discuss 6 months later. He remains the only Supreme Court justice known to have resigned over principle. We cannot marshal through judicial history without recounting the renowned great dissenter, Justice John Marshall Harlan. Named for our 4th Chief Justice, Harlan is most remembered as the lone dissenting voice in Plessy versus Ferguson. That case upheld the odious principle that separate but equal was consistent with our Constitution. This left black Americans to generations of segregation throughout this country. It wasn't until the landmark case of Brown versus Board of Education, almost 60 years later, that the doctrine was properly relegated to the ash heap of history. In his seminal dissent, Harlan wrote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or his color when his civil rights, as guaranteed by the supreme law of the land, are involved." He then accurately predicted that Plessy will one day be condemned as one of the most pernicious decisions of the Supreme Court. To those that fought so hard for progress and individual liberty, I'm sure Harlan's dissent was a small but significant consolation. Frederick Douglass wrote to Justice Harlan about his Plessy dissent and said it was the greatest legal treatise in decades, that it should be scattered like the leaves of autumn over the whole country and be seen, read, and pondered upon by every citizen of the country. I personally found inspiration in his powerful dissent when I first came about it in college. They became to me the embodiment of the highest ideals of this country, and Harlan remains my model of judicial courage. As a Kentuckian and even a former slaveholder himself, it could not have been an easy decision to be the lone dissenter on the court on racial issues. But dissent he did, and he did so forcefully and eloquently, his dissent is now for the ages. As a wonderful new book by Peter Canellis observes, Justice Harlan turned out the act of dissenting into an appeal to the next generation of jurists. He spent thousands of hours holed up under gas lamps, creating doctrines that would find their true light in the electric future. In my view, Harlan wrote not just for his time, but for ours. In doing so, Harlan demonstrated incredible foresight. As Canellis observed, Harlan's prescience, his ability to look over the horizon and envision American life 100 years in the future, was extraordinary. Justice Harlan remains the best example of Cardozo's description of the dissenter, as one who speaks of the future with his voice pitched to a key that will carry through the years. Now, for the sake of time, I will fast forward to the modern era of the court. Otherwise, we'll be here all night. The modern era can be characterized by the continued proliferation of dissents. From 1801 to 1940, which coincides from Marshall to Chief Justice Hughes, there were dissents in roughly 77% of cases. About 1941 to 1997, which coincides with Chief Justice Stone to Rehnquist, there were dissents in 52% of cases. Some commentators have noted that we see so many separate writings on the Supreme Court today that we have de facto returned to the era of seriatim decisions. As far as individual dissents, few can deny the impact that Justice Scalia and Justice Ginsburg had on modern jurisprudence. While their majority opinions deserve study and respect, their powerful and incisive dissents should be elevated for how they move both the public and the law. I'd like to highlight one for each. First, for Justice Scalia. Perhaps his most prophetic was his lone dissent in Morrison versus Olson. In that case, he called for the Independent Counsel Act to be struck down as unconstitutional. Who can forget Justice Scalia's timeless line about the affront to the separation of powers in that case? While the concentration of power in one branch often comes in sheep's clothing, he said, but this wolf comes as a wolf. While speaking here at Stanford, Justice Kagan called this one of the greatest dissents ever written, and every year it gets better. Sure enough, Scalia's view about the independent counsel law won the day, and Congress let the law expire in 1999. Justice Ginsburg was also able to spur congressional action with her spirited dissent in Ledbetter versus Goodyear. In that equal pay case, Justice Ginsburg admonished the court for, quote, failing to comprehend or being indifferent to the insidious ways in which women can be victims of pay discrimination. Title VII, she said, the anti-discrimination statute, she said, was meant to govern real-world employment practices, and that world is what the court ignores. Justice Ginsburg later said she wrote that dissent with Congress in mind as the audience. And sure enough, Congress listened and later passed the Lilly-Ledbetter Fair Pay Act. Given this history, where does this leave us? Is the rise of dissents a good thing, or does it diminish the authority and legitimacy of the court? It's important to understand both sides of the argument, even though I ultimately come down in favor of vigorous dissent. In the camp against dissents, there is the general sense that the separate opinions attract from the strength of the court's message by undermining the unity of its interpretation of the law. One could argue there are certain areas of law, such as those affecting economic or commercial affairs, where consistency should be most important and prevail. As Justice Brandeis famously wrote, it's more important that the applicable rule of law be settled than it be settled right. A court that decides cases unanimously, the thinking often goes, would legitimize the nation's law, as well as improve lower courts' ability to interpret them consistently and coherently. When a judge dissents, some view the act as prioritizing the publication of one's personal opinion over the opportunity to work collaboratively or to craft new precedent. A judge who dissents too often may undermine the weight of her words and to damage the collegial atmosphere of the court. The effect of judges constantly writing separate opinions can also damage the institutional legacy of the court, especially when the majority and dissents are often split along partisan lines. For those who value finality and certainty of clear rules and holdings, writing separately undermines that goal. Authoring dissents and concurrences liberates a judge from the burden of writing presidential opinions. A judge has a free hand to broadly expand on any area of the law, knowing that the writing is not binding on anyone. Many see this as an unnecessary distraction from a unified court, just so that a judge can grandstand about his or her beliefs about in dictum. This gives rise to another criticism, that separate writings are merely advisory opinions in violation of Article 3. On the other hand, proponents for separate opinions often argue that they democratize the judiciary, rendering it more transparent to the public and thus strengthening its legitimacy and credibility. In a healthy, engaged democracy, courts' decisions should result from vigorous and thoughtful legal analysis, not secret deliberations and facades of unanimity. Unanimity is an appealing distraction, Justice Frankfurter once said, but a single court statement on important constitutional issues is bound to smother differences that in the interest of candor and of the best interest of the court ought to be expressed. Furthermore, no one could deny the critical role that many famous dissents have played in enhancing the legitimacy of the court. As Justice Scalia said, dissents augment rather than diminish the prestige of the court. When history demonstrates that one of the court's decision has been a truly horrendous mistake, and I imagine Justice Scalia had Plessy or Dred Scott in mind, he said, "It is comforting and conducive of respect for the court to look back and realize that at least some of the justices saw the danger clearly and gave voice, often eloquent voice, to their concern." Dissents also open dialogue within a court. Being tested by contrary views allows judges to strengthen their own writing, improving the law. As Justice Ginsburg put it, there is nothing better than an impressive dissent to lead the author of the majority opinion to refine and clarify her initial circulation. As an example, Justice Ginsburg pointed to her majority opinion in the United States versus Virginia. In that case, the VMI, the Virginia Military Institute, the court held that the denial of admission of women to the institute violated the 14th Amendment. The final draft, she said, was ever so much better than my first, second, and at least a dozen more drafts, thanks to Justice Scalia's attention-grabbing dissent. Scalia, for his part, added, "The first draft of a dissent often causes the majority to refine its opinion, eliminating the more vulnerable assertions and narrowing the announced legal rule." I can attest that this applies in the circuit courts as well. I've witnessed firsthand how the exchange of ideas that comes with separate writings can vastly improve the finished product. In fact, just last week, I deleted an entire section of a proposed opinion that I wrote because I recognized that the dissent had the better of the argument on that issue. Dissents aren't only useful as mechanisms for dialogue within a court, they also have communicative value to the public. Some, like Justice Brandeis, wrote lengthy dissents in constitutional cases with the stated purpose to educate the country. It is a valid purpose, I think, to inspire public debate through artful dissents. It is also true that airing disagreement can reassure the public that all views were considered and that decisions were not arrived at lightly. Dissents can also direct legislative efforts, as we've seen in examples of Justice Scalia and Justice Ginsburg. But perhaps the most compelling justification for judicial dissents is the role they play in mediating constitutional dialogue across time. Powerful dissents have time and time again been vindicated long after their author's lifetime. Jefferson had studied such cases in England when there was, he said, when there was 3 opinions against one, the reasoning of one was so much the most cogent as to become afterwards the law of the land. Indeed, many of the most celebrated dissents fit this description. We've talked about Justice Harlan's dissent in Plessy and Curtis's dissent in Dred Scott, but there are many others. So what are we to make of this discussion? Here are my parting thoughts. First, dissenting helps facilitate and foster dialogue, whether within the courts, between branches of government, or with the public, or whether they appeal for a better tomorrow. The open exchange of ideas and perspectives is essential to maintaining the quality of our decision-making process. There may be a time and a place for silence and unanimity, but surely that's rarely the case when it comes to important matters such as defending the Constitution. Second, we can't discount the cost of separate writings. Clarity, consistency, and legitimacy of the courts may suffer. So we must be discerning in dissent. To paraphrase Justice Ginsburg, the shots of a dissent fall harder when you choose your ground wisely. Of course, that means understanding the difference between dissenting and trolling. The next thing I'd like to say that there are life lessons here. Don't give up on civil discourse, dialogue, and friendships with your classmates and colleagues from across the spectrum. No matter how intense the difference of opinions, I see no reason why it should affect collegiality or common respect for each other. Our judiciary has managed to function through some difficult periods of history, but it requires openness to dialogue and civility. While I have often vigorously dissented from my colleagues on the Ninth Circuit, it doesn't detract from my respect and admiration for them as jurists. And one thing to note, as polarized as this country has been, in the last term, 40% of Supreme Court cases were decided 9-0, unanimous. That's 40%, 4 and 10. And that's with the Supreme Court taking on the hardest, most difficult cases in the nation. Lastly, during the brief time you have in law school, don't be afraid to dissent or adopt separate opinions, as several of you did today. Using this opportunity to open vigorous dialogue on the law and other matters of public importance is vitally important. Accept and embrace your differences and cherish your freedoms to express them. Use dissenting voice to strengthen your own views and avoid the impulse to shut down debate. I've used Justices Scalia and Ginsburg as examples several times during this presentation. With your indulgence, I'd like to close with one last one. It is well known that they vehemently disagreed on the outcomes of many, many cases. But it is also well known that they regarded each other as the best of friends. Let their enduring friendship serve as a reminder that there is more that unites us than divides us. In remembering Justice Scalia, Justice Ginsburg alluded to a duet from the 2015 opera Scalia-Ginsburg entitled, "We Are Different, We Are One." Yes, she wrote, we are different in our interpretation of written text, but one in our respect and affection for each other, and above all, our reverence for the Constitution and the court. In legal practice, as in life, you will find that mutual respect and recognition of our shared values will only sharpen your voice and make us stronger as a community. Thank you for having me here today.
Thank you so much, Judge Bumatay. That was a great lecture. And now I'm delighted to open it up to Q&A. I will walk around the room. Just raise your hand, and I'll bring the mic to you. And so please feel free to ask away. Tough questions welcome.
Not too tough. Just kidding.
What are your thoughts on the role of concurring opinions? Like, in what ways do they play similar or different roles from dissents?
And I should have said this. Can you say your name and who you are, if you're a student, and what year?
Oh, I'm Sherwin. I'm Sherwin. I'm a undergrad sophomore at Stanford.
Thanks, Sherwin.
I think the same pros and cons can be used against concurrences. I write concurrences often, and the idea is that you might agree with the outcome in the case, but there's a reason why the law should change in the future, or maybe court precedent, even though it's binding on me as a judge. I disagree with it and think it should be reviewed or changed over time. So that's a valid use of concurrence. I use it quite often when I disagree with the precedent of the Ninth Circuit.
My name is Joe. I'm an alumnus of Stanford Law School, and very appreciative to have you here today. Thank you very much. I was going to ask about your experience with en banc process on the Ninth Circuit. So some similarities to the dissents and the debate that goes on before even taking on the case.
Yeah, that's a great question. There's been the rise of something called the dissental, and I was going to talk about it if I had time, but dissentals are known as a dissent for the denial of rehearing en banc. And you'll see, and if you look at the statistics on the Ninth Circuit, they've been around for a while in the Ninth Circuit, but 5 years ago, there was only dissentals in 42% of cases, of en banc cases. Last year, I think it was up to 86%. And frankly, I might be guilty part of that. I wrote in 7 myself. So, but I think I value that process, and I think it's an important process because just because we're not on the panel, that doesn't mean that he as a judge doesn't care about the outcome in that case or what the state of the law is in that case. And so the en banc process allows me to weigh in and say, I think this panel got it wrong. I think we should all take a hard look at it and review it. And often these en banc votes fail. And I don't think there's anything wrong with me writing a dissental to say to the court, to the Supreme Court, to my other colleagues, to students and practitioners out there that I think this area of law is wrong. It's something that needs to be looked at. And so I often write dissentals, and I think that's an important part of my job.
No, okay. Hi, I'm Mike.
I'm just going to say, the reason why I'm holding on the mic is so that we don't spread germs. I'm just going to hold it. I know it's a little awkward. I'm invisible.
Okay. I'm Michael. I'm an alum at Stanford Law. And I'm curious about what you think, since you mentioned that there were dissents that were not explained, they didn't have reasoning about why they were dissenting. What role you think that plays or doesn't play, and so long as we're, drawing broader life lessons from the law, to what extent does dissenting without, really explaining your reasons, just in politics or in life on Facebook, does that play a role? Sometimes, what times should we be favoring, really explaining our reasons, all that?
Right. First of all, you did disclose you're also my former clerk, so anyway. Although that's a pretty hard question. So I think dissenting without giving reason is a bad thing. My understanding of why that happened during that era of the Supreme Court is frankly it was personalities. People didn't like each other and they didn't want to be associated with the decision, even if they agreed with it, but they just, for whatever extra legal reasons, they refused to defend that reason. And the one takeaway of my talk, the one takeaway you should all have is that dissenting is very good, and we should dissent, but the purpose should be to foster dialogue, not for any personal reasons or just don't want to be associated with that justice. So I think that practice was bad, and I'm glad we don't see it anymore.
Hi, I'm Christina. I'm actually a Berkeley alum. I hope that's okay.
You may proceed, nonetheless.
I teach legal studies at the Stanford Online High School. So you alluded to the special problems that can crop up when dissents fall particularly along party lines, which
Yes.
seems like a place where it could go too far and open lots of gates for sort of speculation about where the court's going next and, say, state legislation that counts on it. I wonder if you can speak to the sort of balance between party line associated dissent and dissent that walks out on other grounds.
Yeah, that's a difficult question. I mean, it's often something we're asked, and I would say this: I don't think any judge votes in a case for political reasons or for partisan reasons. I think what you'll see is that judges often have strong ideological views, and that comes out in these dissents. I'm troubled by that practice. I have to say, admittedly, when I got on the court, I was surprised to see how often some of these, especially on the bond cases, follow a little along, I wouldn't call it party line, but a party, let's put it this way, you could predict which way the vote would go. And I've been disappointed by that, and I've been especially careful and mindful that I don't fall into that trap. And I don't know if there's much we could do about it, but the positive note on all that is that en banc cases are very rare. I think last year we had 30 votes on en banc cases, out of thousands and thousands of cases. And I would say this, that I am probably one of the more frequent dissenters on the Ninth Circuit, is my understanding. But I've only written 22 dissents out of over 400 cases I've been on. So as much as I talk about dissents, and I think it's important, but what we should understand is there's so much unity on the court, and that's what we could take away and focus on as well.
Hi, I'm Tiffany. I'm not associated with the law school or anything, but I work for Stanford at the museum. I was kind of curious and confused a bit. When you first began speaking, a group of students seemed to leave the talk, and you had characterized that as dissent. But they didn't stay to listen to hear what was happening. And so I'm just kind of curious if you could speak more about what does listening, is that factoring into dissent or not?
Obviously, I think students could express themselves in any way they want. I think, and the act of the walking out probably was a dissent that will be noted, and I think that's fine. But I would say this, dissent really should inspire debate. I was hoping someone would come back and ask me why that happened. I'd be happy to answer any of those questions. And I think that's a better way to start a dialogue rather than making the statement. But to each their own.
Hi, my name is Danny. I'm a first-year Stanford Law student here. I have a two-part question. The first part is, to what extent, given your experience on the Ninth Circuit, is there attempts at persuasion after oral argument? And then the second question is, you had mentioned during previous eras of high levels of polarization, there seemed to be an increased acerbic tone to the dissents. And I'm wondering if you could talk about, in our current era of polarization, if you foresee that already seeping into the opinions that are being written, or if you think that'll happen more frequently going forward.
Very good questions. I will say this, I'll speak for myself. I've thought about this issue. Is my job in conference, so the way it works, we have oral argument, we go into a back room, we conference, we all discuss the case, we all give our opinions on how the case should come out. And I wonder what my role should be. Should I advocate for the way I think the case should come out? And generally, I've decided the answer is no. These are other Article III judges who clearly understand the case and made through the decision, and they've come to a conclusion. And I just don't see myself as to try and change their position. And I think other judges have a different view, and there'll be a give and take and a discussion about how the outcome can be. Or, for example, if the divergence is small, we will discuss about ways to coming to a compromise that could get us to the same ground. But for me, I don't view myself in that role. Of course, if I think there's a factual mistake or there's a judgment, I might try to say, well, have you considered that? I mean, maybe this is the case. But otherwise, there's not a give and take, at least from my perspective. On your second question, I do worry about the tone of dissents. I think dissentals in particular have gained notoriety in the press and on Twitter because sometimes they often do use this colorful language that makes it easily to digest. And I guess I would say this, I'm on the fence on that. As I said earlier, at all times we should be respectful and give due deference to the other judges and my colleagues on the Ninth Circuit. On the other hand, when you put a dissent in colorful languages, more people will hear about it, and maybe that will inspire more debate. So personally, I'm on the line of respectful dissent. I have colleagues and dear colleagues that I think have taken a different tack, And I'm not criticizing that. I think there might be some value there.
I think we probably have time for one more question. No pressure. Yes. Excuse me.
Hi, I'm Kanika. I'm an advanced degree student, so I'm from India. So pardon me if this sounds like it doesn't make sense. But you said that you meet first. Like, is that right? So like, there's an oral argument, and then the judges come together, and then you kind of discuss, and then say there's a group that says, oh well, we're going to do one thing, and then certain people are dissenting. Is it likely that once the opinions are written, you come back to have another discussion, and then maybe people switch sides, and then the written opinions go around? Like, how does it work?
Yeah, so I would say this, it's rare that we come back in person to rediscuss the case, but so once the conference happens, usually there's a writing assignment, one person is in charge of the majority opinion, and if there's a dissent, someone will come back on a dissenting opinion, and then the majority opinion gets circulated to the full panel, and then the dissent gets circulated to the full panel, and that often leads to debate and flipping sides. As I mentioned earlier, I wrote a whole section of opinion, and the dissent came back and just kind of eviscerated it. I'm like, ooh, I had to cut it out. And so when that happens, we don't often meet in person, but we'll say, I'm having second thoughts on this, and sometimes we ask for a supplemental briefing, for example, if we see it, because of the writing led to us to see the issue in a different way, then we'll ask for briefing on that issue. That happens all the time, and people often change their mind. I will say this, I've changed my mind several times during oral argument, during conference, and post-conference, so it happens. So anyone who says, when you become an advocate out there, oral argument is important, I think it can change minds. So that's my tip, my practice tip. You can get CLE credit now. Is that?
So thank you very much. I was going to say, please join me in a round of applause for our speaker, but you preempted me. The great minds run in the same direction. That was a really stimulating talk. I especially appreciate the way you connect the practice on the courts with the way all of us as citizens and students and scholars ought to engage with one another. So I took a lot from that. So thank you. And let me invite everyone here to join us for a reception out in the courtyard, either through either of these doors, and Judge Bumatay will be there to chat, and of course we'll be chatting with one another as well. So please join us. But thank you very much. Great talk.
Thank you. Thanks for having me.